Good afternoon, Professor. I'm Gavin Martinez, and this is my partner, Kevin Ward. And today we will be presenting on Goldman versus Weinberger. So to preface you, in the Goldman versus Weinberger case, it was pretty much a discussion on the violation of the First Amendment. So in 1986, the Supreme Court ruled that the U.S. Armed Forces did not violate military personnel's First Amendment rights by prohibiting soldiers from wearing any religious apparel. So in this part of the presentation, I, Gavin Martinez, will be reviewing Weinberger, who he was, and his relation to the case. I will be going over the legal religious issues, and at the end, I will share my opinions on the case.
I'm Kevin Ward. I'll be going over who Goldman was, the basic facts of the case, and I'll also be discussing my opinions on the case. Simji Goldman, at the time of his suit, was a psychologist in the military. He's the petitioner for this case. He is an Orthodox Jew and ordained rabbi, as well as a psychologist, like I said. His education was paid for by a scholarship from the Air Force, and it required 3 years of active service after he got his degree.
So Caspar W. Weinberger was the main respondent in this case, and he also was the Secretary of Defense.
So for the basic facts of this case, at the time of his first suit, the petitioner was serving the United States Air Force as a psychologist. As was previously stated, he's an Orthodox Jew and ordained rabbi, and as such, he wore a yarmulke. Now, till 1981, the petitioner was able to wear his yarmulke on base. Up to this point, he had remained close to his duty station in the health clinic and always wore a service cap over his yarmulke when out of doors. In April, however, he testified at a court-martial, and a complaint was lodged against him since he was not wearing his service cap and only his yarmulke. The opposing counsel lodged a complaint with his commanding officer, Colonel Joseph Gregory, the hospital commander, which Goldman worked at as the psychologist. Gregory did enforce the regulation that partially on Goldman. The regulation in question states that headgear will not be worn while indoors except by armed security, police in the performance of their duties, and police in the performance of their duties. This is regulation AFR 3510. Colonel Gregory conveyed the message to Goldman and told the petitioner not to violate the regulation outside the hospital. The petitioner refused, however, despite the majority of his time being spent in the hospital, and his attorney protested to the Air Force General Counsel. In response, the colonel changed his original response to only enforce in part. He changed it to enforce in full, refusing to let the petitioner wear his yarmulke even while inside the hospital. The petitioner then brought a suit against the respondent and others, securing an injunctive against the enforcement of the regulation. He secured this on the grounds that it violated his first right, the First Amendment right to a free exercise of religion. However, on appeal, the court reversed the verdict, instead holding that the Air Force's interest in uniformity and rendered the enforcement of the regulation permissible. On criteria, this decision was supported. The court affirmed that the holding of the Air Force's regulation did not infringe on the petitioner's right to freedom of religion based on the First Amendment, since the Air Force reasonably and even-handedly regulated dress in the interest of uniformity and discipline.
So regarding the legal religious issues, in this case, the petitioner sued the respondent, which is the Secretary of Defense, as he believed his right to exercise free religion was being infringed upon. Petitioner Goldman contended that the Air Force had to make an exemption to his uniform dress. He bases his argument based in the free exercise clause of the First Amendment, which is the protection of religion and the freedom to exercise it. He argued that unless the Air Force could identify how his religious apparel could create a quote unquote clear danger to discipline, then they must make an exemption for him. Further, he expounds upon that generally visible but unobtrusive apparel does not create any danger. So the religious issues in the Goldman versus Weinberger case center around the fact that whether the individual's right to free practice of religion triumphs over the Air Force's interest of uniformity and discipline. So in a 7-4 decision, the Supreme Court decided that the Air Force's regulations did not infringe upon the First Amendment right of freedom. So the petitioner believes that as the Air Force failed to provide an exact example of what clear danger was, the Yamaka presents that their argument is merely unproven. He states that there is no support from actual experience or any sort of scientific study in the record that would classify this as danger. So in fact, the petitioner states that the excerpt witnesses suggest that religious exemptions are in fact desirable and will increase morale in the Air Force. But on the contrary, a quote from Justice Reinhardt says, whether or not expert witnesses may feel that religious exemptions to AFR 3510 are desirable is quite beside the point. The desirability of dress regulations in the military is decided by appropriate military officials, and they are under no constitutional mandate to abandon their considered professional judgment. Now, personally, I think this is kind of ridiculous that the officials' professional judgment can cloud our rights as Americans, and especially our First Amendment right to freedom of religion. So the Air Force has drawn the line essentially between religious apparel that is visible and religious apparel and which is not, which is they're clearly favoring and choosing to be really hard on what is visible rather than what isn't. So on the dissenting opinions, a belief is fronted by Justice Brennan in the words of Chief Justice Warren that our citizens in uniform may not be stripped of basic rights simply because they have doffed their civilian clothes. The religious issues then come down to whether free exercise of religion is trumped by the military strategic interest in uniformity.
So we disagree with the court's ruling. While there is weight behind the court's decision to support military discretion, it is not enough to completely disregard the individual's right to free exercise of religion. I personally agree with the Chief Justice's statement that our citizens in uniform may not be stripped of basic rights simply because they have doffed their clothes. And further, Justice Brennan's dissenting opinion, in which he argues that the military service is a burden the free exercise of right for its members, there must be a credible explanation of how the practice is likely to interfere with the military's preferred interest. I personally agree with that there must be a clear reason. Further, the Air Force's own regulations allow actually for deviance from the dress code. Air Force Regulation 3510 further states, appearance in uniform is an important part of this image. Neither the Air Force nor the public expects absolute uniformity of appearance. Each member has the right, within limits, to express individuality through his or her appearance. However, the image of a disciplined service member who can be relied on to do his or her job excludes the extreme, the unusual, and the fad. Justice Brennan states, and I personally agree with him, that a serviceman wearing a yarmulke is not extreme, unusual, or fadishous. It is reasonable. However, another argument that's propagated by the court's decision to enforce the Air Force's regulation is that there is no way to distinguish fairly between external shows of religion, and therefore its only course is to prohibit them all. While this seems fair at first glance, Brennan points out, and once again, I do agree with him here, that this neutral standard actually is biased against religions that show religious apparel and is more favored towards those that don't. So there is discrimination here, it's just not on the surface. It would be equally, just as unjust it would be to have a Jew be allowed to wear their yarmulke while a Sikh would not be allowed to wear their turban. It would be equally unjust to forbid them both from wearing their own religious apparel while allowing other religious groups that don't have religious apparel to practice their beliefs. Now, if there's a rule in place, there should be a reason for it, and a clear one at that. Justice Blackmun states that rules are rules, and he's right And he continues, it's not sufficient justification for infringing liberty. My bad. He meant, sorry. Justice Blackmun says in his dissenting opinion that rules are rules, arguing that it's not a sufficient reason for infringing upon religious liberty. What he's saying here is that you can't just say a rule, it's a rule, without backing it up. So it is important to discern what you're talking about. That's why we disagree with the court's ruling in this case.
Absolutely, yeah. Backing up what Kevin said completely, we are in favor of the petitioner. And actually, in 1987, the case was brought to Congress and it was actually overturned. And Jews were actually allowed to wear their yarmulkes after this court case got overturned in the Congress in 1987. So that just goes to show when it was taken to the Supreme Court, their ruling was definitely unjust and unconstitutional as it was overturned the next year. So yeah, thank you for listening to our presentation on Goldman versus Weinberger. I'm Gavin Martinez and this is Kevin Ward, and we appreciate your time. Thank you.